Good morning and welcome to today's webinar. Today's topic is how to uphold the Bank Secrecy Act, keeping safeguards in effect. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Madison Cummins and I'm today's webinar organizer. As a reminder, this is an interactive session, so please submit your questions through the question button on the control panel. Questions will be addressed at the conclusion of the presentation. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the slides will be sent to all attendees. You will also be receiving a certificate of training for attending this webinar in its entirety. Lastly, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. Now for the moment everyone's been waiting for, I would like to introduce today's presenter, Matt Urban. Matt works with credit union collection managers and other decision makers in Pittsburgh and throughout the state of Pennsylvania to evaluate and find effective solutions for their business and legal needs. He spends the majority of his time strategizing with credit unions to build and implement consumer collections programs, including the collection of outstanding receivables, delinquent accounts, and charged off debts. Without further ado, I'll now hand it over to Matt.
Thanks, Madison, and good morning, everyone. Thanks for attending today. It's everyone's favorite time of the year. It's time to get recertified in your BSA training requirements, and I'm happy to be the one to take you on that voyage today. I hope everyone had a nice Thanksgiving and is can't believe it's December already, and we're quickly rolling towards the end of the year. So let's get going here and see if we can't get this taken care of. Today's agenda, obviously, Madison gave you a little bit of an overview of us. We'll talk about also the goals of the Bank Secrecy Act, minimum requirements for the financial industry, money laundering, the CIP program, record keeping, and types of reports. All standard stuff that you've heard before, really nothing earth-shattering or new that we have here to go over. But again, it's always like with everything, it's always good to get a refresher on what the standards and what the requirements are in the ever-changing regulatory world. Certainly, I think as you've heard, a lot of you have probably heard from us already. In the debt collection world, Reg F went into effect as of yesterday and sort of changed the way that you guys have to send us collection accounts and the notices that have to go out, and when an account gets open, the good news for the credit unions on the call is your original creditors. You don't have to, these changes don't apply to you, other than filling out a new form from us and can putting down a little bit of different information. It should be pretty much status quo as far as getting collection accounts and moving forward. But again, that's just an example of the way things are changing. And I think everyone's obviously paid close attention to the possibility of new reporting requirements for bank accounts for under $600, or whether it's whatever it might be, whatever IRS scheme they're cooking up to track down additional revenue. So again, these are things that are always changing. That's why it's important to spend time reviewing things like the BSA. Because you never know. You never know when something's going to change. You never know why it's going to change or how it's going to change. But again, the nice thing is, we're here to provide you that information to be able to give you an idea as to what to expect and how to navigate those changes. Again, Madison sort of talked about me a little bit. Obviously, for those of you on the call who are clients, we certainly appreciate you. And certainly, we represent creditors across the country, credit unions across the country in all types of areas: consumer collections, bankruptcy, commercial collections, any litigation matters, foreclosures, those types of things. Anything involves a creditor, then we're certainly here to help. So, without further ado, let's go ahead and get into the contents here. And of course, what's good a presentation without giving a little overview of what we're talking about. So, The Bank Secrecy Act. And of course, I will, as most of us refer to it as BSA. Certainly during the presentation, I'll slip in and out between calling it the BSA or Bank Secrecy Act. Just sort of the nature of the beast when you're dealing with these long names and acronyms and everything along those lines. But the BSA is also known as the Currency and Foreign Transactions Reporting Act, the anti-money laundering law. Now you can see why they call it the BSA. Try saying that 10 times fast. It's passed by Congress in 1970. Just like a lot of, it seems like a lot of these consumer protection statutes and these types of statutes were passed right around that time. I mean, you see it with the Fair Debt Collection Practices Act in the late 70s. The Fair Credit Reporting Act was also in the 70s, and also the BSA. So these statutes, these regulations, these laws were enacted, 40, 50 years ago. And certainly, as we all know, I mean, the world is certainly the world changed 2 years ago, and continues to change daily. But and that's sort of the issue with some of these laws. They were passed 50 years ago whenever things were a lot different, and they've never been updated, or they've been updated, piecemeal and incrementally, to not be able to sort of stay up with the modern times. And as we certainly know, especially in the financial crimes area, I mean, internet, mobile transactions, and everything along those lines, it really is I won't say the wild, wild west, but it is. I mean, there's just so many ways that the bad guys are trying to stay ahead and coming up with new ways to keep ahead. So it's just one of those things that that's why it's important to pay attention to these statutes and also the regulations that go along with it, and sort of how the case law and things like that. And that goes for any of these older consumer financial protection statutes. But the BSA requires U.S. financial institutions to assist government agencies to detect and prevent money laundering. All credit unions and financial institutions must comply with BSA regulations. Some of the other goals: safeguarding financial industries from threats posed by money laundering and illicit finance. Sort of referenced that there. I mean, obviously that's the goal. And that's also not only a goal, it's a challenge. Ensure systems, procedures, and programs are in place to protect industry from threats. That's like with any program that you have, whether it be, I teach a webinar on fair credit reporting, and people always ask me, Matt, what do you, how can I prevent something from happening? And my answer is, you can't prevent it from happening. That's the problem. That's the challenge. But what you can do is you can make sure that you have good policies in place, good procedures in place. Your system is current. You attend webinars like this one to make sure that you're staying compliant with any changes or regulations that have come down the line in the past year. So there's obviously no way to avoid, just like with anything in life, you can try to minimize risk, but you can't eliminate it. And the things that you can do are the things that we'll talk about here today. Obviously you're going to train the industry to recognize and report fraud, and ensure record keeping and reporting systems are in place to help prevent, deter, investigate, and prosecute financial crime. So again, it's important to have policies and procedures in place. So where does all this come from? Well, the Code of Federal Regulations. I can get into sort of a civics class of how a bill becomes a law and everything like that, but I'm not going to bore everyone with that information. But again, the Congress passed the BSA, and then the agencies in charge of them issue regulations that essentially are the way that they try to keep up with the changes. And of course, there's supposed to be comment period on regulations, and the ability for the industry to be able to comment and whatnot. Over the past couple, past decade or so, that's the regulation departments in the government has been quite busy, and sometimes not necessarily getting the necessary feedback from different entities involved in these things. But that's a different topic for a different day. But again, so CFR, the Code of Federal Regulations, requires all credit unions to establish BSA compliance programs. You must designate an individual responsible for coordinating and monitoring day-to-day compliance. It must establish and maintain customer identification programs, CIPs. You must provide training for appropriate personnel. Must provide a system for a system of it. Must provide for a system of internal controls to ensure ongoing compliance. It must provide independent testing for compliance to be conducted by credit union personnel or outside parties. So, with that being said, obviously that's sort of a little bit of a background of it. Nothing new there. Let's talk about what your requirements are as financial industry, your financial industry requirements. What is required? So, the minimum industry requirements: establish a system of internal controls for ongoing compliance. Seems pretty simple. You have a compliance program. If you do, great. You've checked off that first box. Designate individuals responsible for compliance management, compliance officer. I'm assuming most of us have compliance officers or somebody who wears the hat of the compliance officer, because certainly, depending on the size of your credit union, it's going to be a situation where, obviously you wear many hats, whether it's collection officer, compliance officer, you name it, you might wear that hat, and that's for that in that specific day or hour by hour or minute by minute, perhaps. So that individual is going to coordinate and monitor day-to-day compliance among employees and within the entire financial industry, regularly communicates with financial industry's governing bodies and authority to carry out compliance tasks. Some additional industry requirements: delegate additional duties appropriately, communicate, establish procedures to all parties, and personnel training, specific policies and procedures under FinCEN, adequate examples of suspicious activity, appropriate steps to take. In addition, you're going to have to conduct independent BSA compliance tests. Are you doing those? If you're not, you should be doing them. Review overall compliance. Review individual monitoring systems for suspicious activity reports, Sars, currency transaction reports, and other reporting instruments. Complexity may depend on products, services, customer size, and/or geographic location. So, we're going to kind of stop there for a second, because people always ask me, whether it's for BSA or any type of compliance program that you put together, do I need to do this? Do I need to do that? And the question is, well, there certainly shouldn't be a one-size-fits-all approach to anything, because if you're a $10 million asset credit union and you have limited products, and you are located in a rural part of the world, then perhaps you may not need to have as a complex of a system as a $5 billion asset credit union who has transactions coming in from all across the world. So again, these are sort of common sense approaches, and I think too often in the consumer protection world and in these financial regulations, too often we get sort of hamstrung by the idea of it's got to be this one-size-fits-all approach. The CFPB is pretty good at that, trying to say, well, just because Chase Manhattan Bank and other large financial institutions do things a certain way, then they assume that a credit union in the middle of Pennsylvania or Ohio should do things the exact same way, when in fact they're not built that way. They're different, and that's certainly one of the struggles that you see, that I know a lot of you see when trying to implement policies and procedures and comply with anything from the BSA to anything else. So obviously, what are some of the challenges that we face? Capture the data. Certainly, if you don't capture it, then there's nothing. I mean, if you don't have something in place to be able to discover the bad deed, then the bad deed is going to go and proceed unfettered, and there's going to be no way to stop it until perhaps it's too late. Once you capture that data, you're going to convey it to the compliance officer. Obviously, at that point, it's been known, and now it's time to determine what are the next steps. What are we going to do? How are we going to do it to make sure that we're trying to stop the bad actors in their tracks. And then, of course, once you have the information and it's been relayed to the appropriate parties, you got to make sure that the appropriate reports are filed, so that you're able to, get it to authorities who are in a position to investigate and to hopefully, if there is any bad deeds going on, to hopefully, stop those in the tracks. Remember, you're not the police. You're not the district attorney's office. You're not required to conduct criminal investigations and make determinations on whether somebody is violated the law or not. Your role and duty is to gather the information and get it to the appropriate parties so they can do the investigation. And certainly, if you don't do those things, then it creates a breach in the financial system that could not only impact your credit union, your financial institution, it could certainly impact the overall financial industry as well. It could be a way to stop a potential industry-wide issue. And certainly, if you don't comply, there's going to be penalties and fines. So the next topic we'll get into is money laundering. And let's talk about some of the steps of money laundering. So the first step, obviously, is the money has to be placed. So this is clearly the first and most vulnerable stage. The thief attempts to introduce unlawful proceeds into the financial system without attracting attention. Well, no doubt. I mean, that's why they're a thief. They're a criminal. They're trying to hopefully work under the radar without gathering any attention. So they try to be creative with how they're doing their deed. So some of the common placement techniques that exist: structuring deposits in amounts to evade reporting requirements, large deposits made in smaller, less conspicuous amounts, refund check deposits from canceled vacation or insurance policies, purchasing a series of monetary instruments, cashier's checks, money orders that are then collected and deposited to another branch or financial institution. The second stage is layering. And that's going to involve moving funds around the financial system, often in a complex series of transactions. Creates confusion and complicates the paper trails. So again, they want to infiltrate the system, and they don't want to be noticed. Then they want to start shuffling things around, moving things around. So they don't want to arouse any further suspicion. That's I wonder what's going on here. Why all of a sudden are these large transactions coming in from overseas? The old African money scheme where somebody's sending you money and they want you to deposit it and all those types of things that unbelievably people fall for. But these are the things that are going on. Some of the common techniques of layering: exchanging monetary instruments for larger or smaller amounts, wiring or transferring funds through numerous accounts in one or more financial institutions. Again, the idea is to hide the ball. So after those two steps, obviously the final step of the process is integration. And again, that's the ultimate goal. So it creates the appearance of legality, though, through additional transactions. Further shields the criminal from a recorded connection to the funds by providing a plausible explanation for the source. Clearly, the idea is to simply say, "Who, me? I didn't do it. I don't know what you're talking about. These are all perfectly legitimate transactions. I haven't done anything inappropriate in any way, shape, or form. I've worked within the bounds of the law, and so you're just gonna, it's not me." And the good ones are obviously are the ones who are doing it and having success at it. So what are some examples? Purchase and resale of real estate, investment securities, Ford trusts, other assets. Again, putting money where you don't think it's going to be, or you don't expect it to be. It's like, oh well, we're going to put it into here and it seems legitimate, or things that someone may not necessarily be looking at closely, or as closely as they might otherwise do it. It's certainly a lot different than the bank, or the robber coming into the bank and saying, "Hey, give me all the money," and walking out the front door. So these are different types of crooks. So the next step in our adventure here is the member identification program, the CIP program. So CIP, identity verification procedures, excuse me. We're going to include risk-based procedures for verifying members' identity to the extent reasonable and practicable. Ability to form a reasonable belief that the member's true identity is known, based on assessment of relevant risks, including varying types of accounts offered, methods available for opening an account, types of identifying information available, credit union size, location, and member base. And again, a couple key phrases in there, and these are sort of legal terms of art that us lawyers like to use, and because they're built in statutes and sort of what the what the standard is. But in the second point, their ability to form a reasonable belief that the member's true identity is known. Reasonable belief doesn't mean that you have to be 100% certain. A reasonable belief means a reasonable person or a reasonable financial employee involved in these things is able to form a belief or form a determination that in this case the member's true identity is known. So if they obviously are providing you with certain reliable forms of communication, then you have a reasonable belief to assume that John Doe is in fact John Doe, or again, as opposed to a situation where they're giving you they're giving you a gym membership and it looks like they made it in their basement last night, those types of things. So again, it's sort of an absurd example, but again, an example nonetheless that because I get questions a lot of times. Well, I'm just not really sure. I don't know 100% for sure. I want to be certain. I hear words like I want to be certain, and my response commonly is, yes, it's nice to be certain, but if you've done what you need to do and followed the proper procedures, and everything you're seeing is pointing to the fact that in this case the member says that who they are is who they are, and you've documented these things and you have proof of that, then you've met your burden and obligation underneath the law. So clearly, procedures for opening an account must exist. That's pretty much common sense. You must specify what identifying information shall be obtained from each member. Again, these are things that you should have in your policies and procedures. At a minimum, must include the following: name and date of birth for an individual. Well, that makes sense. The address. Address again. We start getting into different types of address. Obviously, if it's a person, or a business, street address for an individual. No PO boxes. Army or fleet post office number, or street address of next of kin individuals without street address. Again, clearly, if you're in the military, you certainly have a right to open an account. But again, a lot of folks in the military, sort of move from place to place. I have a brother-in-law who's in the Navy, and he moves every 2 years. So it's tough to get a beat on him. So again, these are common sense ways of handling things. The principal place of business, local office, or other physical location for a person other than an individual. So again, we're talking about businesses, entities, things of that nature. Identification number, which shall be tax identification number for a U.S. individual. It's a Social Security number. Clearly, that's that's easy, that's simple, that's straightforward for a person. For a non-U.S. person, again, this is where it gets, it starts getting a little more complicated, because there are people that are in the country who have a right to be in the country and are have legal status, who are entitled to be able to get access to services such as opening an account. But some of the things you're looking for a non-U.S. person, one or more of the following: taxpayer identification number, again, Social Security number, passport number and a country of issuance, alien identification card, something like a green card, a number and country of issuance of any other government issued document, including nationality or residence, and must bear a photograph or a similar safeguard. What are some non-documentary methods? Again, those are all the things we just covered are things that exist. They're tangible. You can look at an ID card. You can look at a passport. You can look at a green card. You can look at these things and be able to examine them and make a determination as to the legitimacy and their their validity. But certainly there are other ways of doing it, and those are the non-documentary methods. Credit unions relying on non-documentary methods of verification must document procedures in the CIP. Methods may include, again, this includes, but may, it could include other things. But methods may include contacting a member, independently verifying the member's identity, compare information provided with the information obtained, consumer reporting agency, any other type of public database, checking references with other financial institutions, obtaining a financial statement. If you're utilizing some of these non-documentary procedures, the following potential situations must be addressed. An individual is unable to present a valid government-issued identification that bears a photograph or similar safeguard. Credit union is not familiar with the documents presented. An account is open without obtaining documents. Account is open without appearing in person. Other circumstances that increase the risk, that is, the true identity of the member cannot be verified. Again, you'll want to be able to get as much information as you possibly can about the person who is obviously coming in to be your member, who is coming in to open an account. There needs to be information. You need to be able to provide that and to have that in that member's account file in case there is a situation where where there could be issues. You simply just don't want to have somebody walk in and open an account and they dump a bunch of money in, and next thing you know, you're in the middle of a international financial criminal syndicate. Again, these are why these policies and procedures are in place to make sure that you're able to satisfy these requirements. So lack of verification, let's talk about that for a minute. When a credit union cannot form a reasonable belief, there's that word again, reasonable belief, that it knows the member's true identity procedures must exist to cover that situation. Terms under which a member may use an account while the credit union attempts to verify the member's identity. When an account should be closed after attempts to verify a member's identity have failed, and when a SAR, suspicious activity report, should be filed. So again, if you've looked at everything they presented and you've done some digging and try to do your homework, and everything's telling you that it doesn't look right and they're using non-documentary methods, and you can't get a beat on the person in terms of references or anything like that. That's a reasonable belief that that you can't figure out their true identity. And at that point, what do you do? What's the next step in the process? And clearly, your policies and procedures must exist to deal with that, because it could be as simple as, listen, we're just going to close the account down. I mean, they just opened it up. There was, they really didn't put any money into the account. Those types of things. I mean, obviously, but if it reaches to the limits of where you have to file SAR, then you file SAR. But again, make sure that you have these procedures in place. Review them. Again, you're on the webinar today. Today's a good time to review those procedures. Record keeping. Everyone loves to keep records because, again, it's important. As I say that facetiously, because record keeping requires time and storing these records. But again, it's important, and it's important because if you don't have the records and somebody comes a knocking and asking you, well, what about this? What do your records show? What documents do you show? Because there was some criminal activity going on, and you say none, then that's not a good answer. So, what are some of the procedures for making and maintaining records of all information obtained? Supporting documentation shall be made available, obviously, to any federal, state, or local law enforcement agency, any federal regulatory authority that examines the credit union for BSA compliance. Records must be retained for 5 years. It's bolded, so it's important. So for 5 years from the date the account was closed or the date that record was made. At a minimum, the record must include all identifying information obtained about a member, description of any document relied upon noting type of document, any identification number contained in said document, the place of issuance, the date of issuance, and any expiration date. A description of verification methods and results, and resolution of any substantive discrepancy discovered. Again, pretty much common sense stuff, all the things we talked about in the previous slides. Next thing, comparison with government lists. Determining whether the member appears on any list of known or suspected terrorists or terrorist organizations issued by any federal government agency. The OFAC is specially designated nationals, another acronym, SDN. Determination must be made within a reasonable period of time after the account is open. All federal directives issued in connection with such lists must be followed. So again, government has lists. Cross-reference those lists and make sure that you're keeping up to date with the current version of the list. Members must be provided adequate notice that the information has been requested to verify their identity. Describe the information requirements and provide notice in a manner reasonably designed to ensure that the member is able to view the notice or is otherwise given notice before opening an account. Again, most of us have these things posted on the door or somewhere in the lobby, on a website, wherever, on applications, wherever it's, we typically would put these things. That's where it needs to go. So certainly, notice is an important part of this. And make sure that your notices are in a location that are reasonably can be reasonably be seen. Again, if you put it outside of the break room, behind the counter, that's not a good place for the notice. Put it out front, put it outside the teller's window or whatever it might be, so the member knows and has noticed that, hey, these are the things we're going to have to provide. We're going to be looking for. Next stage, we're going to go ahead and talk about the Sars, the Suspicious Activity Report. So when does a SAR have to be filed? SAR must be filed if the credit union knows, suspects, or has reason to suspect that any crime or suspicious transaction related to money laundering activity or violation of the BSA has occurred. You have these things highlighted. So again, as I always say, if they're bolded, they're important. So knows, I mean, that's pretty easy. If you clearly, if you're looking at something and you know that they're up to no good, you got to issue a SAR. Suspects, and then of course we're getting down the line a little bit where it's like, well, I don't know for sure, but I suspect based on all the circumstances around me that there is money laundering going on, or has reason to suspect. These reason to suspect, again, is certainly more of a term of art. It is it's very it's not, there's not one size fits all definition for it. Reason to suspect a lot of times you're looking at a situation where there's red flags out there, and everything you're seeing out there, it's not clear to the point where it's like, I really know this, or I'm pretty sure, but you see a lot of red flags out there that exist, that people are, that there's something going on. That's what reason to suspect means. It's to the point where you're looking around, it's like, you know what, I really think there's something going on here. So again, these are sort of legal terms of art. But again, they're important to sort of talk about because they're different standards. Management must properly notify its board of directors or designated committee of any SAR filed. It's not required for a robbery or burglary. Obviously, you want to report those to the appropriate authorities. Common types of SARs: money laundering, check fraud, mortgage loan fraud, credit card fraud, consumer loan fraud. Anything you can imagine that the word ends that it ends in fraud, check kiting, counterfeit checks, ID thefts, false statements. Again, these are all pretty straightforward. The SAR and any other information that would reveal the existence of a SAR is confidential and shall not be disclosed. Clearly, that makes sense. You don't want to let the criminal know that, hey, I suspect that I know that you're up to no good, so I'm going to let you know, so you can clear out and get a head start. I use an example, and when I do this presentation, I always talk about when I do bank garnishments on bank attachments and collections. And people always say, why didn't you let me know that you were going to attach my bank account? I said, well, what would you have done if I would have told you that I was going to do that? So we would have taken all the money out. I said, exactly. And that's why the rules of procedure allow me not to give you notice until after the account's been put on hold. Same thing here. You clearly, you don't want to give them a heads up as to what's going on. And you also don't want to be in a position where you're potentially, it could be wrong. You don't want to be, it has to be confidential to make sure that people are willing to issue these SARs, because if there was liability for if you're wrong, that you could be potentially opening yourself up for some sort of slander or defamation, then people will be very reluctant financial institutions should be very reluctant to comply, because it's like, well, we have to be very sure, because otherwise we get our pantsuit off. So any request to disclose a SAR or any information that would reveal the existence of a SAR should be declined, and immediately notify the appropriate regulatory entities. SARs are not subject to subpoenas, and a credit union or agent of making a voluntary disclosure of any possible violation of law or regulation to a government agency shall be protected from liability. So there you go. There is quote unquote immunity for disclosing information to government agencies, because again, it's important to make sure that we're keeping an eye out for these things. So what are some reportable activity? Insider abuse involving any amount. Transactions aggregating. There's some examples. $5,000 plus where a suspect can be identified. $25,000 plus regardless of a potential suspect. And $5,000 plus that involve potential money laundering or BSA violations. Transactions that fall into any of the following. They involve funds derived from illegal activities or intended or conducted in order to hide or disguise funds or assets derived from legal activities, are part of a plan to violate or evade any federal law or regulation, or to avoid any transaction reporting requirement under such law. Designed to evade any BSA requirements, have no business or apparent lawful purpose. What to file and where and when to file. So what to file? You're going to file a suspicious transaction. A suspicious transaction shall be reported by a SAR, clearly. That's what we're talking about. Collect and maintain supporting documentation and information. You want to keep a record. There you go. There's that record part. When to file. No later than 30 calendar days after initially detected. So again, it's not something that has to be done immediately, because again, a lot of times you may not be able to detect or gather the information you need to immediately figure out that something good isn't going on. So you have time to do it to see how things develop. And again, if they're good, you're not going to know right away. If no suspect was identified on the date detected, filing may be delayed by an additional 30 calendar days. Reporting should not be delayed by more than 60 calendar days. So again, you have some time, because again, it may not reveal itself right away. Where to file? You're going to file it with FinCEN. How to file? Mandatory electronic filing. That was in July of 2012. And SAR currency transaction reports were required in 2013. Standardized SAR for everyone. Save template and fill in the member information. So they standardized it, made it a lot simpler instead of having 50 million versions of a particular form. So SAR filing in a shared branching situation. In cases affecting multiple branches, which credit union is responsible for filing? Technically, both must report. However, FinCEN does not want to receive multiple reports. Decide which party will report in your shared branching agreement. Confidentiality. The subject of the SAR cannot know of its filing, and allows for a joint SAR filing. So again, all the stuff that we had already previously discussed. So moving on, currency transaction reports. What are these and what do they do? So currency transaction reports are used for transactions that are greater than $10,000 of the foreign equivalent. Deposits, withdrawals, exchange of currency or any other payment or transfer by or through or into a credit union. Foreign transactions where CTR is required, verify and record the individual's information. Again, basic stuff. Name, identity, whatever the identity is, address, account number, social security or taxpayer identification, if any. Parties to report in a CTR. Deposits, anyone benefiting from the transaction, joint account holders included. Withdrawals, only the person conducting the transaction. unless other information knows or leads you to believe others will benefit from the transaction. So again, when there's deposits of over $10,000, anyone benefiting from the transaction, including joint account holders. Withdrawals, again, only the person conducting the transaction, unless you have reason to believe. And again, that's one of those terms of art. You're looking at everything and you see, you know what, this person's involved based on everything I'm seeing. Report that as well. So here's some examples. Wife withdraws $12,000 and doesn't say what it's for. Report the wife. Why? Because she withdrawed over $10,000 and there's no other information to suggest otherwise. Husband deposits $12,000. Again, we're assuming that there's a joint account here. We're going to report both because their husband and wife are both on the account and it's over $10,000. Wife withdraws $12,000 and says it's for a car for her and her husband. Okay, there's the withdrawal, there's the key. We're over $10,000, we're at 12, and she discloses the reason for the money and the money being used, and it's to get a car for her and her husband. So you're going to report both. When do we file these? So we're going to file within 15 days following the day on which the reportable transaction occurred. How to file? Again, file it with FinCEN. Copies of the report shall be kept for, again, 5 years from the date of the report. Cash in, cash out transactions may be reported on the same CTR if they both qualify as reportable transactions. Transactions should not be offset against one another. Again, so that's a situation where you're, oh well, you know, I'm depositing 20, but I'm taking out, or I'm depositing 19, but I'm taking out 9 or whatever it might be. I think my math's off. But again, something that wouldn't go above those thresholds. Again, if they both qualify as reportable transactions, you're going to be reporting on the same one. So again, you can't offset. So here's an example. A member deposits $11,000 into a savings account and withdraws $3,000 from the checking. What should you file? Well, a CTR for the savings account deposit should be filed because, again, it's over $10,000, but not for the withdrawal because, again, it's only $3,000. Example 2, member deposits $6,000 into the savings. They withdraw $4,000 from their checking and present $6,500 in U.S. currency exchange for a foreign currency. What should you do? One CTR with more than one entry, because the cash in the transaction is reportable for a total amount of $12,500. The $6,000 deposit plus the $6,500 currency transaction. And the cash out transaction is reportable for the amount of $10,500 because you're withdrawing $4,000 and they're getting $6,500 returned in the foreign currency. So again, there's one CTR, but you're having multiple entities because there are multiple events. Aggregation, multiple branches, multiple transactions. So we've kind of already talked about that a little bit. Let's go into it a little bit further, but structured transactions. The definition of structure or structuring: no person shall, for purposes of evading the CTR requirements with respect to such transactions, cause or attempt to cause a credit union to fail to file CTR. Cause or attempt to cause a credit union to file CTR that contains a material omission or misstatement of fact, or structure or assist in structuring or attempt to structure or assisting in structuring any transaction. CTR is not required for any transaction between an exempt person and credit union. Exempt persons include another financial institution, department or agency of the U.S. or any state or any political subdivision of any state. So, what's an example? Exempt persons continued, any entity established under the laws of the U.S., of any state or any political subdivision or under any interstate compact, 2 or more states. Basically, the long and short of it is any type of government entity. I'm not going to read that entire thing and get tongue-tied over it, just like any good government statute and anything like that. It's quite redundant. But again, another example of an exempt person is businesses within the U.S. or a state. So, more examples. Any other non-listed business that maintains a transaction account for at least 2 months, frequently engages in transactions in excess of $10,000, or is incorporated is incorporated or organized under the laws of the U.S. or a state, or is registered as eligible to do business. So what are you going to do? You're going to designate you designate an exempt person by filing FinCEN Form 110, not required for currency transfers to and from any of the 12 Federal Reserve banks or exempt person list. Designation must occur within 30 days of the reportable transaction, and it has to be an annual review. Again, you can't get it on this list and stay on the list. There needs to be, at a bare minimum, an annual review to see if that status is still valid. Some ineligible businesses. A business engaged primarily or in one or more of the following activities may not be treated as a non-listed business. Purchase or sale to members of motor vehicles of any kind, vessels, aircraft, farm equipment, or mobile homes. The practice of law, accountancy, or medicine, auctioning of goods, chartering or operations of ships or aircrafts, gaming of any kind, investment advisory services or investment banking, real estate brokerage, pawnbrokers, title insurance and real estate closing, trade union activities, any other activities that may be specified by FinCEN. So again, these are the typical types of businesses that are generally doing larger transactions. Currency purchases of monetary instruments. Record keeping is only required in these situations if daily purchases aggregate $3,000 or more. If the purchaser has a deposit account with a financial institution, you're going to need the name of the purchaser, the purchase date, the type of instrument purchased, serial number on each instrument purchased, dollar amount of each instrument purchased as well. You're going to verify the identification of the purchaser, a signature card, non-members, examination of a document normally acceptable within the bank community as means of identification, and which contains the purchaser's name and address. So again, all the things you've done to identify people before, they all apply in these situations as well. Let's talk about wire transfers. So wire transfers, originating bank transfers money in excess of $3,000. You're going to need the name and address of the originator, the amount, the execution date, payment instructions, and the identity of the beneficiary bank. Information sharing. So federal, state, and local law enforcement agencies investigating terrorist activity or money laundering may request FinCEN solicit certain information from a financial institution. After receipt of a completed certification from a law enforcement agency, FinCEN may require a record search to determine whether or not the financial institution maintains accounts or engages in transactions with any specified individual or entity or organization. Upon request, financial institutions must conduct a one-time search of its records, including current accounts, accounts maintained during the previous 12-month period, and transactions conducted outside of an account by or on behalf of a named suspect during the preceding 6 months. Positive matches must be reported to FinCEN within 14 days via the SISS system. No details shall be provided other than the fact that there is a match. Negative responses are not required. Financial institutions may only use the information for reporting to determine whether to establish or maintain an account or engage in a transaction or to assist in BSA compliance. Subject lists are not permanent watch lists. Subject lists generally relate to one-time inquiries and are not updated or corrected if an investigation is dropped, a prosecution is declined, or the subject is exonerated. Inclusion on a subject list should not be for the sole factor used to determine whether or not to file SAR. Actions taken pursuant to information provided in a request from FinCEN do not affect the financial institution's obligations to comply with the rules and regulations of OFAC, respond to any legal process, or to file a SAR and immediately notify law enforcement if necessary. So again, the moral of the story is that you still have to follow your policies and procedures, and just because you get a request from FinCEN doesn't mean everything else goes flying out the door. Financial institutions may not disclose their primary banking regulator, the law enforcement agency requesting the information, the fact that a request has been made. Documentation of the search was performed is essential. SISS search self-verification document, copies of the form returned to FinCEN, and documentation. What about voluntary sharing? Well, information sharing is certainly encouraged to identify and report activities involving terrorist activity or money laundering. Specific protection from civil liability is provided. Financial institutions must notify FinCEN of its intent to engage in information sharing. You must establish and maintain adequate procedures to protect the security and confidentiality of the information. Processes and policies should be developed and implemented for sharing and receiving information. Notice to share information is effective for 1 year. Must take reasonable steps to verify that the other financial institution with which it intends to share information has also submitted the required notice to FinCEN. Certainly, you can do your sharing, make sure you're following the necessary steps. Information received from other financial institutions is subject to the same use of restrictions and confidentiality requirements of required information sharing. Financial institutions are not authorized to share a SAR or disclose its existence, non-existence. We talked about that earlier. Information obtained under Section 314B may be used to determine whether or not to file a SAR. So we saw that OFAC before. Now let's talk about it a little bit. The Office of Foreign Assets Controls. Policies, procedures, and processes. Designate an OFAC officer. Make sure you have independent testing. Tell me if you haven't heard all this before. Screening requirements, new accounts, current members, non-members, member account access, determining whether OFAC hits are valid or false positives. Report positive matches to OFAC within 10 business days. Policies and procedures also are required for reporting blocked funds to OFAC. Depending on the nature of the sanction, transactions to or from entities identified as a positive hit must either be blocked and account funds frozen, or the transaction is rejected. And certainly, you want to make sure you have training to comply with all the requirements necessary as required by OFAC. So what are some of the commonly cited violations that we run into, that we see? The BSA AML risk assessment not detailed, MDD procedures not specifically documented, inadequate MDD and MSBs, inadequate MDD on shared branching or third party, SARs are not completed correctly in narrative. So again, I mean, what we're looking at are things such as, do you have good policies and procedures in place? Are you documenting things? Are you keeping good records? All the basic things that we talked about. Some of the additional cited violations: CTRs fail to list all beneficiaries. No specific OFAC risk assessment. Weak or undocumented OFAC policies and procedures. No procedures for reviewing law enforcement requests. Training deficiencies. Typical things that you would see in any type of compliance situation where someone is cited, and it's common. There's just you don't have the proper procedures in place. You're not attending webinars like this to get certification. There's no training, no testing of these systems, things of that nature. But again, remember, you have to. All these things are all going to be, there isn't a one-size-fits-all approach to it. It needs to be consistent with the nature of your financial institution and how you conduct business. So, what are some penalties? As you can imagine, there are different types of penalties, and they run the gamut from civil, criminal, or intangible penalties. Federal banking agencies and FinCEN can bring civil money penalties, raising from anywhere from $500 to $500,000. Criminal penalties are going to throw you in prison for 1 to 10 years, possibly. Directors and staff may be permanently banned from the credit union industry, and everyday non-compliance is a separate violation. So clearly, you don't want to have these violations being stacked upon you. So again, have good systems in place. Because if there's an issue one day and there's going to be an issue the next day, and it's going to stack up quickly. So what are some fraud prevention tips as we wrap up here? Use due diligence to help detect fraudulent transactions. Pretty straightforward. Does the transaction make sense? Is it a large amount of money? Invert the problem. Consider the situation from a thieves' perspective. Ask questions. Again, nothing earth-shattering here. Just use some common sense. If it doesn't seem right, it's too good to be true. It's probably not true. It's always a good adage to keep, and no matter what you're doing. And last but not least, some resources for staying up to date. Obviously, the U.S. Department of Treasury Financial Crimes Enforcement Network issues weekly digests via email. NAFQ's daily compliance blog, and of course, we are always putting out information and articles and alerts that they're delivered right to your inbox to keep you up to date. So, with that being said, that wraps up the substance of the presentation. Again, nothing really earth-shattering or anything like that. Fairly straightforward for BSA type of training. Okay, great. Thanks, Madison, and thanks for everyone for attending today. I appreciate it. I'm glad that you allow us to be a resource for the BSA training. It's something we take pride in presenting to everybody a couple times a year. We usually do it in the summertime as well. So certainly, again, we appreciate you being on today, being if you're a client, being a client and participating. And just one thing, real quick, I'm doing a sort of a Zoom call for my clients or any client for that matter to talk about our new transmittal form to comply with Reg F. I'm doing it tomorrow morning at 10. You can reach out to me or Dawn Pagan for some information. We'll just briefly go over how the transmittals form filled out, and to make sure that answer any questions, and I'll also give you a little content as well. Talk about some recent updates in the Fair Credit Reporting Act world. So it'll be about 20 minutes, half hour or so. But again, if that's something you have any questions about, certainly we can assist you with that. And with anything, if you have any questions or I can be of any assistance, please don't hesitate to reach out to me and let me know. And thanks a lot, and I hope everyone has a great end of the year.
Thanks, Matt. And thank you to everyone who attended today's Weltman webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I'd also like to share that we have a complimentary library of over 25 webinars that you and your team can view on demand. Our collection offers information on a variety of topics such as bankruptcy, real estate, and collateral recovery, to name a few. We'll send you a link to the library in our follow-up email, and you will also receive a certificate for attending this training. Thank you again, and have a great rest of your day.